Melania Trump's legal catastrophe. Stay with me here, because what I'm about to walk you through is something we almost never see in American legal history. A First Lady of the United States on the verge of being forced to answer questions under oath about her marriage, her living arrangements, her tax filings, and her connections to Jeffrey Epstein. And the most brutal part? She did this to herself. Her own legal team made a catastrophic miscalculation, and now there may be no clean way out. This isn't speculation. This isn't anonymous sourcing. This is unfolding right now in court, and the implications are staggering. Let me explain exactly how Melania Trump walked into a trap of her own making, and why even a Trump-appointed judge may not be able to rescue her from what comes next. To understand how we got here, the context matters. Back in October, veteran journalist Michael Wolff received a letter, and if you've followed the Trump family for any length of time, you know exactly what kind of letter this was. A demand letter threatening a defamation lawsuit so large it's almost comical. $1 billion. Billion with a B. The letter came from Alejandro Brito, a Coral Gables attorney who has become Donald Trump's go-to legal attack dog for silencing critics. The message was simple: retract what you wrote about Melania Trump and Jeffrey Epstein, issue an apology, or get obliterated financially in court. It's the classic Trump legal posture: maximum threat, maximum intimidation, maximum pressure. And normally, when someone gets one of these letters, they do one of two things. They either comply immediately, issuing what Wolff himself described as North Korean-style confessions and apologies, or they go quiet and hope the storm passes. But Michael Wolff is not most people. He's a veteran investigative journalist. He's written multiple best-selling books about the Trump orbit and the internal chaos of Trump's White House, and he's spent years documenting the dysfunction and secrets the family would prefer buried forever. And when he got that billion-dollar threat, he did something almost nobody does. He sued first. Think about what that means. Instead of cowering, instead of apologizing, instead of going silent, Wolff ran straight to New York State Court and filed a preemptive lawsuit against Melania Trump. In his filing, he laid out the statements her lawyers claimed were defamatory, one by one, and then he explained, in methodical detail, why each one was either demonstrably true, constitutionally protected opinion, fair reporting, or ripped out of context by a legal team using intimidation tactics instead of truth. But Wolff didn't stop at defending himself. He went on offense. He called the Trump legal strategy what it is: a pattern of strategic lawsuits against public participation, slap suits. Lawsuits filed not primarily to win on the merits, but to punish critics, drain resources, and scare other people into silence. The goal isn't truth. The goal is fear. Wolff's argument was essentially, this isn't a serious attempt to correct the record. It's an attempt to break the messenger. And that's where Melania Trump made what could be the biggest legal mistake of her life. Instead of fighting the case where Wolff filed it in New York State Court, her legal team tried to get clever. They filed what's called a notice of removal to move the case into federal court. On the surface, that might look like a smart play. Federal court has different procedures, different judges, and in many cases, defendants believe federal court is cleaner, more predictable, and more favorable than a state court arena. And then, in what can only be described as Trump luck, the random assignment handed the case to Judge Mary Kay East-Cochille, a Trump-appointed federal judge in Manhattan. To Melania's legal team, that probably looked like the jackpot. Federal court, Trump judge, better terrain. Everything should have been going according to plan. But here's what most people miss about federal jurisdiction, and this is where the trap snaps shut. You don't just choose federal court because you like it better. To remove a case from state court to federal court, you need a legal basis for federal jurisdiction. And the most common basis is diversity jurisdiction, meaning the parties must be citizens of different states. If both parties are citizens of the same state, there is no diversity, and the case belongs in state court. Period. Michael Wolff is from New York. That's not in dispute. So if Melania Trump wants this case in federal court, she has to establish that she is not a citizen of New York. She has to prove she's a citizen of a different state, presumably Florida, where the Trump family claims official residence. And the moment she asserts that Wolf's attorneys gain a powerful tool, limited jurisdictional discovery. Let that land. By trying to move this case into federal court, Melania Trump's legal team handed Wolf the right to dig into the question at the center of removal. Where does Melania Trump actually live? And under established federal procedure, when jurisdiction is challenged, the party seeking federal court has the burden to prove the facts supporting it. The opposing side has the right to test that proof through discovery, which means this can quickly get invasive. Depositions, written interrogatories, subpoenas, requests for financial documents, questions about residency, taxes, property filings, and actual day-to-day living patterns. Not gossip, not vibes. The kind of granular, under-oath inquiry that turns private life into public record. So now you see the disaster. Melania didn't just walk into a courtroom. She walked into a legal mechanism that can force her to answer questions under penalty of perjury about the most sensitive parts of her life, all in service of a defamation fight that may not even be strong on the merits. Think about the residency questions alone. Where does she sleep most nights? How many nights per year does she spend at Mar-a-Lago versus Trump Tower in Manhattan versus the White House? Where is her primary home base? Where does she keep her personal belongings? Where is her day-to-day life actually centered? These aren't tabloid questions. In jurisdictional discovery, they become legal questions, and her answers matter. Then you get into taxes. What do her tax filings state about her domicile and residency? Has she claimed Florida residency for tax purposes while living primarily in New York? What about property filings? Florida has a homestead exemption that can provide significant benefits, but to claim it legally, you have to actually reside there. If the filings, the paper trail, and the lived reality don't match, that's a problem. Not a PR problem, a legal problem. And then there's the Barron question, because it's not just about Melania. Barron Trump is a student at NYU in Manhattan. Reporting has long suggested Melania spends much of her time in New York to stay close to her son. If that's true, it becomes relevant to residency claims. And the script flips fast. If you're claiming Florida residency to establish diversity jurisdiction while living primarily in New York, opposing counsel can challenge that claim aggressively. Now, some people will argue, sure, but the judge can protect her. Isco Cheel is a Trump-appointed judge. She can limit discovery. She can narrow questions. She can block the invasive stuff. And here's the problem with that theory. Jurisdiction is not discretionary. When the question is whether federal court has the right to hear the case at all, the rules are explicit. If there's a legitimate dispute over diversity, the party seeking removal must prove it, and the other side has the right to obtain discovery necessary to test it. A judge can manage scope, but a judge cannot pretend the issue doesn't exist. If Wolf's attorneys can articulate a good faith basis for challenging Melania's residency claim, and given years of public reporting about her being in New York, then jurisdictional discovery is not optional. Now let's talk about why this is so devastating, because Melania Trump is walking into all of this exposure in pursuit of a defamation claim that may be remarkably weak. Look at what Wolf actually wrote and what her lawyers claimed was defamatory. The accusation isn't just that he made harsh commentary. It's that he made claims about her involvement in Epstein's orbit and about how she fits into the broader story of Trump's connections. Statement 1. That Melania Trump was very involved in the Epstein situation. Wolf's defense is that this was taken out of context and framed as a claim of fact when the writing itself was descriptive and interpretive, based on reporting and protected by journalistic standards. He's not claiming he fabricated a document. He's describing a story as he understands it, in context, as part of broader reporting. Statement 2. That Melania could be a missing link in Donald Trump's ties to Epstein. Again, Wolf frames this as reporting and analysis, not a criminal allegation, not a definitive statement of guilt. A journalistic thesis, one that, in defamation law, often falls into protected opinion and commentary, especially when it's grounded in disclosed facts and public reporting. Statement 3. That Melania was involved in Epstein's social circle, and that's how she met Trump. Wolf argues that this is supported by the historical record and the social networks around modeling and elite New York circles in that era. The key issue for defamation is whether the statements are false statements of fact made with the requisite false standard, especially for public figures. And if there's documented context, reported connections, and a reasonable basis for the claim, that becomes difficult terrain for a plaintiff. Statement 4, that she was introduced to Trump by a model agent with connections in that same world. Wolf's defense here is essentially, this is part of the reported story of how these circles overlapped. It's not a random invention. It's an assertion grounded in broader context. Statement 5, that Epstein made allegations about Trump and Melania's relationship. Again, Wolf's position is that he's reporting on claims attributed to Epstein, not inventing them, and that this falls into protected reporting territory when presented appropriately. Put it all together, and here's the brutal calculus for Melania. She may now face invasive under oath scrutiny into her residency, her private life, and her financial records, just to pursue a defamation case that, by Wolf's telling, is either true, protected opinion, or a fair characterization of reported facts. That's why this looks like legal malpractice territory. Someone should have seen this coming. Someone should have explained that removal to federal court could trigger jurisdictional discovery. Someone should have weighed the benefit of a federal forum, maybe a more favorable judge, against the cost of forcing the First Lady into a discovery process that exposes exactly the things the Trump machine has historically fought hardest to keep private. But it happened anyway. Either the team miscalculated, or they assumed she'd never actually have to sit, answer, produce, and testify, or they believed the court would shield her automatically. And that's the fatal misunderstanding. Once you enter the federal system and put jurisdiction at issue, the rules don't bend just because you're powerful. Now, the implications extend beyond this single lawsuit. Because what happens if the paper trail doesn't match the public narrative? What happens if filings and claims contradict? What happens if something in tax records conflicts with what she tells the court? Those aren't hypothetical concerns. Those are exactly the kinds of risks attorneys try to avoid, especially for someone as exposed and politically radioactive as a First Lady. So what escape routes does the Trump legal team have now? The options are limited, and none of them are clean. They could try to voluntarily abandon the removal and push the case back to state court, but that's an admission that the federal strategy was a mistake. It also doesn't automatically erase what's already been triggered. Depending on posture and filings, damage can be done the moment jurisdiction becomes contested. They could try to settle with Wolf, but he has shown no sign he wants to settle. He didn't run from the fight. He ran toward it. His entire strategy is to force the truth-testing mechanisms of the legal system into play. They could try to limit discovery, but as I've explained on jurisdiction, the rules are not optional, and judges cannot simply deny basic discovery when the jurisdictional facts are disputed in good faith. And that's why the most likely outcome looks like exactly what Wolf's attorneys want. Melania Trump will be deposed. She will answer questions under oath about residency. Written interrogatories will probe specifics. Records may be demanded. Her answers will be preserved. And a portion of what emerges could become part of a permanent record journalists and investigators can scrutinize for years. For Donald Trump, that is a nightmare scenario. His entire career is built on controlling information, punishing critics, and using legal threats as a weapon to keep unfavorable narratives at bay. This case flips that playbook inside out. The threat letter was supposed to silence. Instead, it triggered a preemptive lawsuit designed to drag the truth into open court. And then, by chasing federal court, Melania's team created the conditions for discovery that could expose exactly what the family most fears: verified facts on the record, under oath, backed by documents. This is the lawsuit Donald Trump fears most, not because of the defamation claims themselves, but because of what discovery can reveal. So here are the 3 things to remember. 1. The decision to remove to federal court was a catastrophic, unforced error. Melania traded the possibility of a more favorable forum for the near certainty of jurisdictional discovery. 2. The substance of the defamation claims appears weak in the face of defenses like truth, protected opinion, and fair reporting, meaning she may be enduring maximum exposure to chase a case she could lose anyway. And 3, this is bigger than Melania Trump. It's about accountability. The Trump legal playbook works best when people are scared and back down. It collapses the moment someone refuses to be intimidated and forces the system to do what it does: demand proof, demand documents, demand sworn answers. That's what we're watching unfold. A first lady facing a legal process that can pry into residency, marriage dynamics, and finances, not as gossip, but as jurisdictional fact. A preemptive lawsuit that turned a billion-dollar threat into a liability. A Trump-appointed judge who may still be bound by federal procedure. And a discovery process that is only just beginning. If you want the next breakdown the moment depositions and filings start landing, subscribe and turn on notifications.